Hello everyone, welcome to today's discussion on a crucial Supreme Court judgment that has sparked debate around freedom of speech and the limit of expression in India. The case we were looked at is Javed Ahmed Hajam versus State of Maharashtra, where the Supreme Court addresses the tension between individual right and public order. At the heart of this case was Section 153A of the IPC Indian Penal Code, which deals with promoting enmity between different groups on the ground of religion, race, etc. And it's used to suppose dissenting voice. The court examined whether an individual right to freedom of speech could be curtailed when their statement or action are seen as potentially disturbing public order. In a significant part of its ruling, the court underscored that dissent is a vital component of democracy and is protected under Article 19, Clause 1, Subclause A of the Indian Constitution, which guarantees the fundamental right to freedom of speech. The court made it clear that mere criticism or expression of dissent against the government action does not automatically constitute an offense under Section 153A. In other words, the court referred that free speech, even when it challenged the status quo, is not something that should be silenced without substantial cause. In today's video, we are all break down the key fact of the case, the argument presented, and the Supreme Court's ruling, which not only upholds the right to free expression but also establishes important boundaries on the use of laws meant to protect public order. This case examines whether the appellant WhatsApp status updating criticizing the abrogation of Article 370 of Indian Constitution constitute an offence under IPC 153A of IPC. The appellant, a professor, faced an FIR challenging that his status promoted enmity between groups. The Supreme Court of India held that the appellant status update did not meet the criteria for invoking Section 153A, emphasizing the freedom of speech and dissent and integral to democracy and protected under Article 19, Clause 1 and Subclause A of the Constitution. The judgment quashed the FIR and the necessity for police sensitization on constitutional freedoms. Introduction and background of judgment. The appellant, a professor, was accused of inciting enmity under Section 153A IPC. Based on his WhatsApp status update, these include messages such as August 5, Black Day, Jammu and Kashmir, and 14th August, Happy Independence Day, Pakistan. The complaint alleged that these messages promote enmity and ill will. The High Court of Judicature of Bombay dismissed the appellant writ petition to quash the FIR, leading to this appeal before the Supreme Court. The case explored critical constitutional values, including the balance between the free speech and public order, while interpreting the scope of Section 153A. Petitioner and appellant argument. The appellant argued that his WhatsApp status represents personal protest and was not intended to incite hatred or enmity. Criticizing Mandar Sayyed Khan versus State of Maharashtra 2007, the appellant contended that mens rea or intention to incite disharmony is crucial under Section 153A. He emphasized that dissent or criticism of the state decision are protected under Article 19, Clause 1 and Subclause A, subject to reasonable restriction. The appellant argued that labeling August 5 a black day and existing goodwill to Pakistan were non-provocative, lawful expression of his view. Respondent argument. The state argued that the impact of the appellant's statement on the public should be determined through evidence. It suggested that the appellant committee had the potential to incite emotional responses among the group members. The prosecutions maintained that the High Court's decision to allow the FIR to proceed was justified and aligned with the need to preserve public order. Judgment. Ratio Descendi. Section 153 AIPC. The court clarified that mere criticism or dissent does not attract Section 153A. The provision requires a clear intent to incite disharmony or hatred between groups, which was absent in this case. Freedom of expression. The court reiterated that dissent is integral to democratic governance. Clause 1, Subclause A. A standard of reasonableness. The court applied the standard of a reasonableness person to assess the alleged impact of the appellant's statement. Arbiter dicta. The court stressed that the need of police education on constitutional principle, particularly freedom of speech. It noted that criminal prosecution should not be used to justify legitimate criticism of government actions. Guidelines. Intent required. Court must examine the mens rea behind statement alleged to incite disharmony. Free speech can only be curtailed under reasonable restriction defined in Article 19, Clause 2nd. Public standard, the effect of speech should be judged by its impact on reasonable, mature individual, not on overly sensitive or intolerant segment of society. Conclusion and comment. The judgment protected freedom of speech from undue interference, referring the importance of dissent in a democracy. It serves as a reminder to law enforcement to avoid misuse of penal provision like Section 153A to suppress constitutional right. Thank you so much.